Do you know how many write-ups you've had?
That's jaw-dropping. 55 write-ups. In the jail system, this screams one thing, a pattern of trouble. Judges pay close attention to this because it shows not just past mistakes, but a mindset that hasn't changed. Think about it. How do you convince a court you've turned your life around when your record says otherwise?
55. I've never seen that many. Here, 18 and a half years. You can't.
Here's a big one, the sentencing cap. The deal ensures the defendant faces between 5 and 30 years. No probation, no light sentence, just prison. This is the justice system drawing a line. When guns and lives are involved, the floor starts at half a decade behind bars.
Be Dr. Jekyll and Mr. Hyde. You can't live. You can, but it's like dancing on a razor blade. It's not safe, and it always leads to destruction. But you can't be good and bad. You got to make a choice. Your choices have to be good. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we are looking at no less than 5 up to 30 years in prison. Regular probation is not an option. And the other thing would be deferred, I guess, or unadjudicated probation.
Classic escalation. What should have been fists became bullets. The prosecutor points out something key. Self-defense claims only work if the threat is direct. But witnesses are lining up to say the gun was never pointed at him. That undercuts the whole defense strategy.
Is that even an option? That's not even an option. It's all straight, flat time. And how old were you at the date of this event? You are now 20, right? 20 years of age now?
Yes, sir.
Okay. All right. State, do you wish to go first? You can go first and last.
Judge, this case originally had 2 people charged. There was an Isaiah Brewer and Mr. McQueen were charged. This was supposed to be just a group of people meeting for a fist fight, and as usual, when a fist fight was about to start, somebody pulls out guns. In this case, the question was always been whether or not there was a self-defense, because the defendant has claimed and still claims today in his pre-sentence report that the victim pulled a gun and pointed it at him and his family, and so he was just defending his family. But the reason that I think he pled is because when we came up for trial, the co-defendant had agreed to testify and was going to testify to the fact that the statement he gave the police was that the victim, while the victim did have a gun, the victim never pointed it at the defendant or any of the family members. And there was also another sister of the defendant, I believe, or a witness that was with the group with the defendant, who also would testify that a gun was never pointed at the defendant or any of the family members. That the minute the argument started, the co-defendant said that the victim had pulled out a gun to point it up in the air to make everybody get away, and that's when Mr. McQueen started shooting and shot about, I forget how many bullets there were fired, but pretty much unloaded his gun, shooting the victim.
And there it is. He admits it. In criminal law, that confession carries weight. Judges may give credit for honesty, but it doesn't erase the crime. It just means the sentence won't climb higher than that 30-year ceiling. Still, admitting you killed someone doesn't win you sympathy when the facts look this bad.
The victim, when he was falling down, then returned fire to shoot back at them, hitting a car, and then did not wound anyone that I know of. This was, once again, one of those shootouts that we have in Beaumont where, unfortunately, someone got killed. And it's all these youngsters running around with guns. And this one, I don't understand why they had to go meet up at the victims across from the victim's sister's house. She claims, the victim's sister claims, that they were chasing her brother and were going to gun him down. and that he never stood a chance, that she heard the shots. She came outside and they were driving away and still shooting out the back of the car. So all this adds up to, we do know that Mr. McQueen, when the police arrested him, he did admit that he's the one that shot and killed the victim. I've given him credit for that.
This is a powerful pivot by the defense. Losing a father at 12, it's tragic, and the lawyer knows jurors and judges alike they are human. But here's the legal reality. Trauma may explain behavior, but it doesn't excuse murder. Courts struggle here. How much weight do you give someone's past pain versus the pain they caused?
Admission for at least owning up to it, and also because there was some other activity out there that was fighting, and I capped it at 30. I think that looking at his history, not only his prior juvenile history, but looking at his history since he's been in jail, you've got a copy, I think, of all the jail incidents, and he hasn't really shown that even if he was wanting to straighten out his life or try to convince the court that he was very remorseful for what he did, his incidents in jail show that he just has no respect for anything or anyone. And so we would ask for the 30 years.
All right, Mr. Kelly.
Thank you, Your Honor. Number of things that are important in this PSI. None, and Mr. Riley, who I think is in the courtroom today, judges who composed this for us for the court. But one of the things that stands out maybe a little bit more than the others is at the beginning of Mr. McQueen's social and personal history, which of course is on page 4 of A. It's the second line. I know the court has seen this already, that Al's dad was Al Drew McQueen Sr., and that he left this earth in 2017. My math is right. Al was 12 at the time when he lost his dad. And I've thought about that through the course of this case, and certainly since we got this.
What year was that?
2017.
Okay.
And more.
What was the date? March 7th, you said? What was the date he lost his dad?
2017. The month is not
Okay.
included. And I've thought about it more since we got this report. Maybe not fair to put myself in his shoes, but as a human being, you can't help that. And to think that when I was 12, my dad was my hero. And to wonder what your life looks like had you been born into different circumstances or had different circumstances. And it's not a completely apt comparison, but hopefully those of us that deal with these hard cases in here every day can at least have an awareness of that. And one of the reasons that it's important is that the court has looked at the pages before that, and Mr. Laird is correct, and he notes some of the issues that Al had as a juvenile, and they line up with those.
That's the heart of it. No matter how many letters of support or tragic backstories, the victim doesn't get another chance. The defense is asking for mercy, but the court has to balance it against the irreversible loss of life. And here's the question for you. What do you think justice looks like in a case like this? Mercy or...
Those same dates. That's where this thing kind of got off the rails a little bit. And I know that Mr. Laird and I have that conversation. The court says it on the record a ton, and whether you want to call it science, whatever it is, those two things go together. There's zero question about that. Those two things go together, and those events, Mr. McQueen Sr. leaving the earth and the beginning of these issues are right there. And they're not excuses, and Al's going to talk in there. They're not excuses, but if we're going to say that a pre-sentence report is at least more than a snapshot of a background, then we have to be fair enough to take those things into account. One of the other things that we mentioned, and the court looked at our letters that are included in our memo to the court, but one of the other things that we mentioned is it's not to devalue anything, but this is, and again, I think Mr. Laird said it exactly accurately. It is tragic in the classical sense that